In 2005, the local Republican Party filed lawsuits before the Illinois State Board of Elections, asserting that Democratic ward organizations were being allowed use of city-rented aldermanic ward offices in which to conduct their political activities without payment of any rent whatsoever. In these cases, we first went to a closed preliminary hearing. In that hearing, we were required only to show that the cases were not a pre-election stunt and had some basis in law and fact. At the hearings in the closed preliminary stage, we brought forward affidavits, photographs, records of ward organization expenses, records of the city vouchers paying the rent for these offices, presented them all to the hearing officer as our case. In the 8 cases currently on appeal, the hearing officer ruled that we had met our burden of proof and the cases should proceed to the next step, which are open preliminary hearings, in effect trials, before the Board of Elections, which are open to the public and the press. After the hearing officer reports were entered, the Illinois State Board of Elections took up the matter for a vote. The Illinois State Board of Elections is an 8-person body containing 4 Democrats and 4 Republicans, which is charged with enforcing the Illinois Election Code. Under prior law, only 4 votes out of the 8 were required to move a case from the closed preliminary hearing to the open preliminary hearing. In 2003, however, the Democratic legislature amended the statute to require 5 votes to move forward to the open preliminary hearing. A key change, since if all 4 members from one party or the other voted against a case, it could not reach the light of day in an open preliminary hearing. After the Board of Elections had dismissed the cases based upon the tie votes, the Republicans filed a petition for judicial review of the matter in the Illinois Appellate Court for the 1st District, sitting in Chicago. In the appeal, we asked the court to rule that the evidence of the Republican Party more than met their minimal burden of proof to move from the closed preliminary hearing to the open preliminary hearing. In the oral argument before the appellate court, after all the briefs were filed, the appellate court raised a new contention, not raised by any of the respondents. That was that the 4-4 vote was in effect a hung jury, which was not a decision that the court could review, since there was no affirmative vote of the board one way or the other. Upon learning this contention of the court, I responded that the denial of judicial review on the merits, because of the tie vote, would result in a constitutional deprivation of equal protection of the law, in that whether there would be judicial review on the merits of the case or not would be determined upon the vote of the board. For example, if the Republicans had lost 8-0, they would be allowed to have judicial review of their case on the merits. But since they lost 4-4, a much closer vote, they would be denied judicial review on the merits. In their opinion, the appellate court upheld their own position that the 4-4 vote was not a decision that could be reviewed by the court. They rejected our constitutional concerns on grounds that they had not been raised in briefs filed months before the court raised the matter in oral argument. Upon receiving the opinion of the appellate court, the Republican Party filed a petition for leave to appeal with the Illinois Supreme Court, asking them to review the case. In the proceedings before the Supreme Court, we are again asking the court to rule that a 4-4 vote is a judicially reviewable vote, resulting in a decision that the courts can change, and if they cannot change this vote, asserting again the constitutional issue that the denial of judicial review because of the 4-4 vote is unconstitutional, thereby rendering void the amendment to the Illinois Election Code, which the Democratic legislature installed some 5 years ago. Our request for relief before the Illinois Supreme Court is in effect the same we have made before the Illinois State Board of Elections and the Illinois Appellate Court, that the rightful case of the Republicans be allowed to proceed to open preliminary hearings in the open light of day.